Hello, everybody. A very happy morning. I am CS Amulya Rajesh and an advocate in practice. And I am here with you all to share some knowledge on interpretation of statutes. How many of you feel interpretation of statutes is a very dry topic? बहुत theory होता है इसमें. How to get out of it? And once I open it, mind goes blowing. All these things usually goes in the minds of the students every time we go with the interpretation of statutes. But then this is such an easy and very important topic, let me say you friends, because only if we know these rules of interpretation, then we can go forward with any sort of law, any sort of statute, and we can get the explanation very correctly. What is basically meant by an interpretation? What is an interpretation? Interpretation is nothing but giving a meaning to any situation, any statute, any sentence. So go with the literal meaning basically. Interpretation means basic understanding. The meaning of any word is called as interpretation. What we understand as an individual is called as an interpretation. Then why interpretation here with us? Yes, because we as professionals have to deal with so many laws, so many acts, so many rules, so many statutes, for which we as professionals understand the intention of the legislature at the time of making the law. Why they have formulated so and so law, we seriously cannot understand unless and until we try to understand it. Just by reading any section, or just by reading any rule, or just by seeing the statute, we cannot basically understand what interpretation is. So we have to try to understand the basic intention, the words behind the literal meaning, right? So interpretation of statute. As we all know, what is meant by a statute? A statute is nothing but the act which has been formulated by the legislature and which is in enforcement, that is called as a statute. So this is very basic. We have three organs of the government, that is legislature, executive, and the judiciary. So the legislature just formulates the laws, enacts the laws, and the executive executes the laws, and the judiciary, it enforces the laws. This is very basic terminology which we have been using since our schooling. So the one organ is making the law and the other organ is trying to enforce it, trying to interpret it. It is the duty of all the professionals, the judges, to understand what law is, understand what the intention of the lawmaker is, understand what is lying behind the lines of the statute. So with this interpretation, we try to decide so many case laws. We try to analyze the litigation. We try to bring out the pros and cons of an act. And when do we really come to this interpretation? See, when we know what the exact meaning is, like for example, we know the meaning of a chair. We need not go beyond it. Chair is something meant for sitting in. That's all. Whereas when we don't know the meaning of some words, when there is an ambiguity, when there is a complexity, when there is a confusion, when the meanings of the words are not clear, in all these situations, we need to go beyond the words, that is interpretation. We need to understand what the actual meaning of the word is, and then understand what is the intention of the mind maker is, and then go forward to come to a conclusion, right? So that is why interpretation of statutes play a very, very, very vital role in our daily lives as professionals. So the primary function of the judiciary, as I told you, it is to enforce the laws. How do they enforce the law? They have to first understand what the litigation is, what the issues involved are, and then understand which act have to be applied with, and then have to come to this interpretation. In this act, what type of interpretation they have to, what type of understanding, what type of conclusion they have to come to. This is very important. There is a very important maxim, Latin maxims. Try remembering this, because once we, in many of the MCQs, we get this Latin maxims as to what the meaning is. A verbis legis non esset residendum, which means that you must not vary the words of the statute while interpreting it. This is very clear. What is understood directly, what word is understood to us easily, it cannot be interpreted in the other way, or it need not be interpreted in a deeper way. It is said in this case law held by the Supreme Court that when there are two interpretations that are possible in the same statute, the one which validates the statute must be preferred, which means validation of statute means what? The basic intention of the statute is being keeping up. So when the intention of bringing the enactment into force has been kept in mind and the interpretation gives two conclusions, we have to choose that conclusion which gives the exact meaning, or which gives the actual interpretation where the statute is enacted for. How do we understand the basic legislation? Or how do we know whether the understanding of those two are keeping up with the statute? For every statute you see, there is a basic preamble. See, if you remember, if you just gaze into our study materials or textbooks or any lessons, for every lesson, we have an objective in the beginning of the lesson. Before introduction of the chapter, we have an objective. The very basic purpose of why the chapter has been put here, and the very, very important point as to how the chapter will deal after we go into it. Okay, just like the objective of every chapter, every lesson in our textbook, we have for a statute a very basic legislation point, that is the preamble. If you observe any act, if you just take any Bare Act, how many of you are aware of Bare Act? A Bare Act is nothing but a plain act as it is formulated or as it is enacted without any explanation. It consists of many provisos, it consists of sections, it consists of subsections. It does not have the explanation, outside explanation. That is a Bare Act. Just the act as it is formulated by the legislature comes in a small Bare Act. And for every Bare Act, if you see, you have a title of the act just to understand what it is, why it is. You have a long title, you have a short title, then you have a preamble. Preamble plays a very, very vital role. Preamble is just like the objective of our chapter or a lesson. So preamble gives the scope as to how the statute is formulated, why the statute is formulated, and what will happen after the statute is applied for. This is what a preamble says. So very instinct, as a layman, anyone can understand a preamble. Whereas to understand the sections, we need to get the aid of all these interpretation rules, construction rules, all these things. Whereas preamble, it is very easy to understand. Just on the face of it, we will get to know what it is. So for every act, how preamble is there. Then we have the second very important thing, That is interpretation or the definition clause. Interpretation or the definition clause is nothing but when you don't understand the meaning that is used in the word of the act. In the act, if you don't understand the meaning of the word, just go to the definition clause. Usually, section 2 and section 3 of the act consist all these definitions or interpretation clauses. What is meant by this? Say, for example, you are incorporating a company and you have to take the declaration from the proposed directors and you need to take an affidavit from the proposed directors. Then, what is meant by affidavit? How do we know what is meant by an affidavit? We usually, just a minute. So what is meant by an affidavit? Affidavit is a self-declaration statement confirming any fact that you yourself is giving on a instrument. That is called as an affidavit. Okay. So this affidavit, the meaning of the affidavit is given none, nowhere. Then how can we understand what an affidavit is? So for that, we need to go. Usually when we don't understand a word, what will we do? That's all. That is my simple question. When you don't know a word, what will you do? You either refer a dictionary or Google what it is. Just the same way, when you don't understand the word that is used in the statute, go refer to the definition clause. Definition clause gives you, because definition clause, let me be clear, it may vary from one statute to another. Say, for example, the definition of a person is one thing in a Companies Act. A definition of a person may differ in Income Tax Act. The definition of a person may also differ in General Clauses Act. I'm just telling you for an example's sake for your understanding. But the definitions may slightly vary, but whatever is the word that is used in the statute, we have to apply that definition only given in our interpretation clause of every statute. Got it? So when we are understanding the definition, we try to understand the definition literally as it is, how the words are framed, how the words are put into. So the first and foremost thing that we need to do while analyzing anything is understand the definition literally, understand the word literally, or interpret the word as it is. Don't go beyond the words. Whatever is the common parlance of understanding, just put that into. Got it? Then, why this basic understanding required? As a whole, we cannot come to a conclusion. So, any act or any section, we have to break the sentences, read in parts, and then combine to come to a conclusion. This is the very essence of the act. It should be a step-by-step process, I tell you, friends. Because understanding a statute is quite easy once we know all these things. Otherwise, reading becomes very difficult for us. Literally understanding becomes very difficult for us. That is why we always have to first thoroughly go through the bare act, understand the terminology, then after making use of the terminology, just go for the interpretation. First, get used to the terminology that is used in the statute. Read the bare act, read the section twice. Once you plainly read the section, you get the words used to your understanding. Then start interpreting it by breaking the sections or breaking the sentences in the parts, taking the literal meanings that are given in the definition clause, and keeping in mind the basic preamble of that statute. Once you do all these things, a step-by-step process, then you will give a good conclusion. You will come around a good interpretation and a conclusion. Then there are some terms which gives some attention, which is nothing but, I told you, the definitions. As I told you, there are some techniques that we need to follow while we are going through the Bare Act. This is very important for the clear understanding of law. So you might have come to a question, why do we need to interpret law? It is the duty of the judges. It is the duty of the judiciary who is taking care of. So why should I? Why should I? There are many cases that you have to safeguard your client as a professional, that whoever comes to you. There will be many cases cropping up before the tribunal where you have to go represent before the board. And it is very, very important for us to understand the basic intention of the legislature, the basic intention of the law. So when we are coming to that, this stage, interpretation plays a very vital role, because one may understand a statute in one way, whereas the other may understand the statute in the other way. There may be more than, everyone's perception is not the same. And to err is human, I tell you, friends. Everyone may not be perfect, or at that time of enactment of the act, that might be prevailing, that might be very important, or that might be very essential for them to make such enactment. Later on, it still got continued. So we have to understand the basic legislation, basic intention, and then go for the conclusion. For this, the step-by-step procedure, as I already told you, preamble plays a very, very important role. So it lets us know the very purpose of the act, why it is given, and how it is given. It is almost like a summary form of the whole act. So it is written in the very start of the act. Every act starts with the preamble. It is the part of the enactment, and preamble does not override the plain provision of the act. So whenever preamble is there, read it just as it is. Don't override plain meaning. Preamble does not override the plain provision of the act, which means the preamble which you are giving in before the act, it should go in conformity with the act. It cannot be against the act. Just like how we have MOA, AOA in our Companies Act, it should go along with the AOA objectives, the MOA objectives, the AOA articles, whatever we are drafting, it should always go in conformity with the MOA only, right? So MOA is the preamble type for the company. Here also, for every act, there is a preamble, and that preamble gives the intention, the objective, the scope of the lawmaker, and why the act has come into existence. We have basic preamble. How many of you remember our Constitution of India? And preamble plays a very vital role, and we, the citizens of India, it starts with. How many of you remember that? Our basic constitution, like after seeing the preamble of the Constitution of India, we come to the basic structure of how India is. That India is a democratic country, India is a socialistic country, India is a secular country. We come to India is a sovereign country. Only it gives the main objective of that. Then after preamble comes the very important thing, that is the definition clause, to understand what is what. Usually I told you section 2 or 3 of the acts gives you the definitions part, and these are defined in the act itself. The words, as I told you, any the word definition person may be varying from act to act. It may vary from statute to statute. So what is more important? What definition is used? What is the scope of the word of person used in that statute is defined under section 2 or 3 of any act. Interpretation clause. We generally call it as interpretation clause because only then we are trying to understand what the definition of the word is. And if the words are not defined, just like how we have a dictionary for the English words, we have a General Clauses Act 1897 to understand any word which is not covered in the definition clause of that particular statute. So if any word is not covered in the statute, say for example, the word affidavit is not covered in Companies Act, I told you, and you have to understand what an affidavit is, go refer General Clauses Act and then get the definition. It's almost like a General Clauses Act is almost like a definition, a dictionary for the statutes. This is very basic act. Let us go through some basic terminology. Before that, till now, did you guys have any doubts? If you have any doubts, please let me know. So I hope everyone is clear with the words statute, interpretation, why we are doing this interpretation of statute. Then with this background, let's move forward. We have some basic terms that is very important for us to understand in our daily professional life. Starting with a word, document. What is a document? Anything that is put in writing is called as a document. Anything that is put in writing on any substance in order to record a fact for the future evidence, it is called as a document. Oral conversations, it will not be a document. Say, for example, I promise to give my friend 1,000 rupees. I said orally to my friend, I promise you, Amulya, that I will give you 1,000 rupees. This is what I told to my friend. Will this constitute a document? No. If the same thing happens to be written on a paper saying that I promise you that I will give you 1,000 rupees. I write it on a paper and I give it to them. This is a document. Anything that is put on a paper, it is called as a document. So it comes like this. Any matter written, expressed or described. Description can be of any form. You describe through a picture. You express through your words. Upon any substance by means of letters, figures or marks. Everything or by one or more than one of those means. So there should be some substance. Substance is the medium on which the words are written or the pictures are written. That is called as a substance. It may be a rock, it may be a paper, it may be an email, whatever it may be. Okay, so anything that is written on any substance using the letters, figures or marks or by more than one of those means intended to be used or which may be used for the purpose of recording a matter. This is very important. I writing on a blackboard now to explain you what a document is. Will it purport or constitute to be a document? No, I will just rub it off once the lecture is over. But what is a document? It should be intended to be used, or which may be used for the purpose of recording a matter. It should be a recorded one. Writing something on a board, writing something on a wall and just rubbing it off, it will not be a document. You keep it on a paper, use it for your later reference, it is called as a document. You engrave it on a stone and keep it there like that, it is a document. All these things now comes, right? Electronic, PDF, Word, all these things are documents. Email, it is a document. You are writing something through a substance called as electronic medium, using the figures, marks, or the letters, and you are intending to use it for the later reference for the purpose of recording the matter. So this is very important. The purpose of recording the matter is very important for you to constitute a document. Got it? So you write something on a paper, it is a document because it is permanent in nature. Understood? Now comes the second word, very important and interesting word, I tell you. Why interesting? Instrument. What is an instrument? Why there is a difference between a document and an instrument? Why two words? Instrument is nothing but which makes the man's life easy. No. Legal definition of instrument, as I told you, a word should be construed in the way that it is enacted. For interpretation of statutes, instrument means this one. Whereas for a science student, instrument can be a tool that is used to make someone's work easy. Understood? But for us professionals, instrument means the every document which records a fact and which creates or confirms the right or liability. As I told you, I promise to give 1,000 rupees to my friend Amulya. Here, when I promise, I am creating a liability for myself that I have to give 1,000 rupees to my friend. And through this wording or through this document or through this writing on a paper, I am giving a right to my friend that she has the right to receive 1,000 rupees because I promised. Got it? So you have a document, but that document should just give a right or should confirm the right or liability. If it is creating the right, I will give 1,000 rupees to my friend Ashok after I sell my car. So after I sell my car, out of the proceeds, whatever I get, I intend to give 1,000 rupees, which creates the rights. I am creating the right here. I am creating a right for the Ashok. Whereas here, confirming the right means I promise to give 1,000 rupees to my friend Rajesh, which means it is confirming the liability on my side and it is confirming the right on the part of the Rajesh. So now it is very clear what is meant by creating a right and what is the confirming a right. Right? So all these things should be a recording of a fact. Only then it is a document, I told you, right? And once the right is created or it is confirmed, it gives rise to a legal document. What is a legal document? A legal document having the legal effect and creating a legal effect, having a legal effect is nothing but creating a right and a liability. What is meant by law? Basically, law is nothing but enforcing your rights and the liabilities. So only when you have a right or a liability, you will go to the court of law. Just like that, for testing or just for fun, you cannot go to the judiciary for enforcing anything, right? Only when it is really important for you, and when you have the right that you have to fight, you have to get something from the person who is liable to give you, only then you go to the court of law. Only then plays the important role of an instrument. So any legal document having the legal effect which creates or confirms the right or a liability, and which is used as an evidence, recording of a fact which is used as an evidence, you call that document as an instrument. Am I making myself clear? Only then you call that document as an instrument. So, why are we always studying about a document instrument? Is it really necessary for us? Will be your basic question. Yes, it is very necessary for us. Say, for example, you as an auditor, you as a chartered accountant, you as a company secretary have to draft number of agreements. You have to prepare number of project reports. You have to draft number of MOUs between the companies, MOU between the individuals, memorandum of understandings between the individuals. So at that point of time, whatever a single word, either it may be is, was, or may be, shall, will, all these small words also plays a very vital role. I tell you, friends, today it might be very easy for us to take what is there in or, what is there in may, what is may there in shall. But these or, may, shall plays a very vital role for you in your future when you're drafting some agreements, deeds, or MOUs with your clients. You as a professional have to keep each and every point in view as to what if I write something or what if I draft something like this, the after effect of this. You draft a sentence today and just imagine the after effect of that. After 5 years, what will be the situation of me drafting this? Or just after 5 minutes, what will be the situation after me drafting this and the parties agree to it? So don't just think about today you drafting this, but think futuristically. This, I tell you, friends, plays a very vital role, because I, being an advocate professional, I see many documents being drafted by the document writers or non-professionals, or just like that, they have created a document for which the generations after generations, the children come and break their heads blowing off. This is very important for us to understand today, that we as a professional have to guide the client in a very particular way in order to minimize the litigation. We as a professional should not encourage the litigation and have to see the smooth functioning of the system. This is very important. That is why this document, instrument, it plays a very vital role. So any document which creates a social or a legal right, which creates a legal right or a liability, and which gives a evidential value to it, it is called as an instrument. And lastly, to put in a very easy manner for you to understand, I tell you, every document may not be an instrument, whereas every instrument is a document. I writing on a paper that Amulya is a very good human being. It is a document because I have kept something in writing and it is there as an evidential value. I am recording a fact. Whereas this will not be an instrument for me, because being Amulya a good human being does not create a liability or a right. it is not an instrument. Whereas Amulya promises Rajesh to give 1,000 rupees, here creates a right or a liability. The liability on the part of the Amulya to give 1,000 rupees to Rajesh, and the right to receive the amount from Amulya is Rajesh's right. In case this doesn't happen, then Rajesh has every right to go to the judiciary, ask for the amount from me through judiciary. Now, in this scenario, after going to judiciary, the judiciary tries to interpret this instrument. Now, initial stages, they have to try to interpret it as it is, as the words are. The first rule. So, am I making myself clear? Every document need not be an instrument, whereas every instrument is a document, something which is written, something which is recording a fact, something which is having an evidential value, merely does not mean it is an instrument. It should create a legal effect, which should create a right or a liability on the parties to whom that instrument is belonging to. This is very important in the examination point of view, the differences between the document and an instrument. Whether all instruments are documents or whether all documents are instruments, this is important. That is why I'm stressing more on this. Types of legal instruments, just for your understanding. A small contract. A contract is nothing but an agreement between two parties having the legal effect, right? Validating the legal effect. So, a contract, a deed. What is meant by a deed again? A contract, a deed, a business document, a will or a codicil, a trust deed, all these things will be a legal instrument. A deed is nothing but something in written, drawing the instrument in the form of the agreement between two parties is called as a deed. An instrument in the form of an agreement between two parties, you can say it is a deed. Otherwise, you have different names. We have various acts which we have to go through. Before continuing further, do you people have any doubts regarding the document or the instrument? Yes, we have a query raised here regarding the instrument and the document. Recording of a fact, how an instrument is referred in this context, and what is the example of such kind of an instrument. This is the example which I wanted to tell you. Recording a fact. Because once a fact is recorded, once you are writing it, it is a record only. But that recording of the fact should give the evidential value. There should be some evidential value for you to understand that there is a legal effect that is created through a right or a liability. Only then, all these things are the examples of the recorded facts only. The contract, to do something between the purchaser and the supplier, I tell you. Contract between the purchaser and the supplier. Or if it is a service organization, an MOU between two parties. A non-disclosure agreements. All these things are instruments only. They are recording the facts as to what it has to happen. So what it has to happen in future, through which you are creating a right on one party and the liability on the one party. And that document or that instrument can be used as an evidential value for this. I hope I made it clear, Mr. Ayush Agarwal. Affording evidence, Yogita. Yeah. Affording evidence is nothing but giving an evidential value. Like you should take up that document or an instrument in the court of law for you to prove that through this document or an instrument, through this instrument or a deed, I got a right to ask certain person that they have to owe me, they are owing me 1,000 rupees and they have to give me 1,000 rupees. So I write it on a paper that I promise to give Rajesh 1,000 rupees. This paper can be used as an instrument which gives a liability on my side and a right to Rajesh to receive 1,000 rupees. In case I fail to give, you can produce this paper as an evidential value before judiciary and show them that yes, Rajesh has the right and the court orders me to pay 1,000 rupees. Okay. Codicil. Codicil and will. Codicil is nothing but the deathbed statement of the dying person. A dying declaration is usually kept in the codicil. A will is when usually it is the last statement that is given. A codicil is the content of the will is called as a codicil. I can tell you that. Any will is a declaration by the person intending to get the act done after his death. That is what is meant by a will. So will only comes into execution after the death of the person who is executing the will. And the contents of the will is called as the codicil. See, the substance for the document or an instrument, substance can be both electronic or even the physical form. Even an email is an evidential value today. It is an instrument. Yeah, the example which I have given, that giving 1,000 rupees to Rajesh, yes, there will be some signatures on it. Only then it creates the rights. Just mere writing it will not create any right or liability. For anything, that signature is very important. And for improving the legal language, I tell you guys, you just follow the materials. Don't go for the explanation given by the our outside materials. You just rely upon the outside materials, but try to follow the board materials or the official materials, the bare acts. Only then you can understand the wordings very easily. We can really follow them. We can understand them. Try to speak a lot using those terminologies. Whenever you're speaking, try to speak a lot using those terminologies. Now, let's go further. For the one who have asked me just whether writing it is an sufficient for creating an instrument, for them the answer is this. Under Indian Stamp Act, Section 2, subsection 14, an instrument is defined as this: a document which is creating, purporting or creating, both are one and the same. A document which is creating a right or a liability, purported to be created, a right or liability to be created or transferred or extended or extinguished or recorded. So these are the 5 things that an instrument should have for. A document will become an instrument once these 5 elements are there. Once it is created, once the right or liability is transferred, once it is extended, once it is extinguished. Extinguishing a right or liability is also an instrument, or recorded. So see here, I have given an example of a simple promissory note. I, Shivani, promise to pay Mr. Mohan or order the sum of rupees 1 lakh only for the value received to Mohandas from Kerala, and the witness stamp signature. So here you are creating a right, and here you are transferring the right. Who is creating a right here? Shivani is creating a right to Mohan, that she has to pay 1 lakh rupees to him, and transfer to any one of him or his order. Usually the promissory note will be like this, either to him or to his order. So you are transferring it from there, and it is extended. The promissory note is an extended form, and it can be the extinguishing of any right also can be an instrument. Any document which extinguishes the right is also an instrument. Say, for example, you have a relinquishment deed. A relinquishment deed is losing one's own right. If I have some property in my name and I lose all my property in favor of my son, I relinquish my right in the property. So I'm losing some right. Even that is an instrument which is having a evidential value, and it is recorded fact. Only then the document can be treated as an instrument. So therefore we can say instrument is a document having the legal effect on the acts, agreements in order to secure the right and an obligation. Right, obligation, liabilities, these are the words which you have to make use of in your daily life, for you to understand the legal terminology in a very better way. Clear? Obligation is nothing but something to be done on the part of the party. Say, for example, A will give 1,000 rupees to B, provided A teaches C. Sorry, B teaches C some maths or science or whatever it is. So it is the obligation on B to teach C. Only then A is liable to pay B. Only then B has the right to take the amount. Understood? A very simple example. Daily life, we get into all these things. Now, what is a deed? Instrument, first the document, and we came to a conclusion that all documents may not be instruments, but all instruments are documents. Now, what is a deed? In order to understand a deed, you have to have the following ingredients. First one, a paper or a parchment, which gives legal effect to the business deal or matter dealt within the court of law. These two are very important. Legally, which gives the legal effect to a business deal or a matter dealt within the court of law, a legal disposition, which means I told you the instruments that you use in your business parlance, that is your MOUs, non-disclosure agreements, all these things that you use in your partnership deed. Are you all getting my point? These are all that are used in the business deal, sale deed, lease deed, all these things are called as deeds. Because you give a legal effect between the parties, in the court of law, it can be disposed. That is how it is called as deed. In India, basically, you don't have much difference between an instrument and a deed. You usually call it deed in a legal parlance. All deeds are instruments, but not vice versa. And deeds and instruments are the same things. As I told you, we usually use them in the interchangeable ways. We don't usually have much difference between them. But instrument only can be a deed. A document as it is cannot be a deed. A deed is basically an agreement between two parties creating a right and a liability. So anything which creates a right and liability is basically an instrument. That is why you can call it as a deed in the legal parlance. See, these are deeds, agreements between two persons creating rights and liabilities. This is basically an instrument, but once it is between two parties, you can say it is a deed, which is creating an evidential value, sale deed, and a rental agreement, lease deed, trust deed, partnership deed. All these things are deeds. So after we understood the basic terminology that we use generally in our regular professional life, we come to the next stage or the important topic, basically the interpretation. And interpretation is nothing but an understanding of the word. This is what we have been telling you from the last first 20 minutes of the session. We have been speaking about the interpretation only a lot. It gives us the basic understanding of the word. Interpretation is nothing but the basic understanding of the word, the meaning of the word. It is almost the same thing that might get repeated, but this is what it is exactly. So say, for example, it is a math formula. A square plus B square is equal to C square. This is very easy for us to understand. And in maths, one is only one. Number one is only one. We cannot have so many alterations. But in a legal interpretation, one can be single, one can be mono. There are several words that we use in our legal parlance. So when we are understanding the words, when we are reading a statute and understanding the words, it is very important for us to concentrate on the interpretation, the meaning, the literal meaning, or the lines behind, words behind, or the intention behind the lines also is very important. So interpretation is basically, as I told you, it is a step-by-step process. In the step-by-step process, all these things plays a very vital role. The preamble, the definition, or the interpretation clause, these plays a very important role for us to understand what is the real meaning of the act. So when it is science or maths, we can prove them. We can just say as it is, and the generations together, it doesn't change. A zero is a zero in math. All right. Whereas for a word in a statute, it may alter. It may alter from time to time. As I told you, substance, document. Previously, we read with the definition of document, substance. 40 years back, substance is not electronic substance. But now, substance includes an email. Even an electronic medium is also creating a right or a liability through that. A written form is also a document. So it changes. When it is changing, we have to understand depending upon the intention. A substance cannot be just understood as it is. A literal meaning of substance will not hold good in this case, because things are changing, right? So with the changing of times, we have to understand the interpretation of that person where he made a law. Clear? So that is why courts take a legislature or the contract between two parties to ascertain the meanings used in such legislature. Some may have an agreement between two parties. In some situations, your clients can have an agreement between two parties where they come with a new proposal, where they come with a new this thing. So when you are doing that, obviously the words that are used in the agreement should be only confined to that agreement only, between the parties' minds only. And once the judiciary is enforcing that agreement, in case there is a litigation and the parties go to the judiciary, then the judiciary have to understand not the literal meaning of the word that is used in the legislature or the document or the agreement, but you have to understand the intention of the people who are drafting that agreement, who drafted that agreement. That is very important there. Merely just using the words or understanding the words or taking the dictionary meaning or going to General Clauses Act will not do good in the changing of times. That is what my intention is. So court need to take the essence of two things when we are interpreting. First thing is the real meaning, and the next thing is intention behind enacting an act or intention behind the parties entering into a contract. This is what I told you. So some may say, some may use the word factory for them to set up any manufacturing unit. Some may use the word property. Some may use the word industry. Some may use the word facility. Okay, but whatever it is, whatever may be the word, the intention is the premises, the factory or the premises or the property or the facility you use in the agreement between the parties, then that word should be considered. Now it is being called as facility generally. Okay, but the intention of the parties is the premises. Understood? That is how it is. When we are understanding the legislation, the real meaning of the word should be understood first of all, then go with the intention of the parties. How does this interpretation helps us? Interpretation helps us in many ways, basically. I tell you, friends, interpretation helps us both in professional as well as in personal lives also. See, basically, when we are angry, we flow words. We throw away words on the other person. When we throw away words, there starts the litigation. Okay. So, first, if we interpret those words as it is, litigation starts. But if we interpret the words behind the intention, we may be coming to a conclusion that, okay, they are in anger or they are in an excitement stage, so they don't know what they are talking. This can be one type of an interpretation to minimize the litigation. The same way, in the professional professional life also, interpretation plays a very, very vital role for us to safeguard our client. Right? So whenever there is an ambiguity in the statute, whenever we don't know what is correct or what is wrong in a statute, which intention has to be applied, which word meaning has to be applied, that is an ambiguity, a confusion stage. So whenever there is a confusion stage in the statute, and when it is getting difficult for us to find out the true sense of the meaning of the word, and we are not understanding what the author is trying to convey to us, then we go for the understanding of the true will of the legislature, not the word of the legislature, but the will of the legislature. So will of the legislature is nothing but the intention of the legislature, which makes us focus on the words and understand the word very much clearly. That is why interpretation will help us to know not only the literal meaning, but also the intention behind the or the lawmaker. This is very important. You might be thinking that from past 1 hour, we have been only speaking about the literal meaning, the intention, but this is all is there in statutes. Just mere literal meaning of the word is just not sufficient for us to understand the intention of the lawmaker. It is more beyond that. We have to go to mainly utilize the purpose of the objective of the act, why this act has come into existence. Importance of interpretation. This is what we have been always speaking till now from the past 1 hour. Why interpretation is important. Yes, interpretation is very important to us. As I told you, whenever we have a confusion, whenever you are unable to draw a conclusion, whenever you are unable to understand the intention, to meet the lawmaker's intention, to meet the very objective of the act, we have to go for the interpretation, a deeper meaning of the literal word. And legislation is an inherent source of law in the statute law. Therefore, interpretation plays an important role. What is a legislation? We have many sources of laws. Sources of laws may be acts. Basic one is legislation. Whatever a lawmaker has made, enacted after passing Lok Sabha, Rajya Sabha, the president's assent, only then comes a law. Just like that, we can't get a law. An enactment is not that very easy to get into force. An enactment has to cross so many stages. We have basically read in our schooling civics. So it has to pass several houses. You have a committee for it, first of all. That committee formulates a bill, and that bill has been introduced in the Lok Sabha, then to the Rajya Sabha, then to the President assent, then comes the bill as an enactment into force. Right? So there is a very lengthy process, and so many masterminds are involved in it to bring a statute into existence, just for the sake of making things smoother. So to make the thing smoother, so many people involved to get the legislation out. But if the intention of that very act is not being survived, then all these things will go sheer waste, right? So that is why interpretation plays a very vital role. Just not to forego things like that, but to make the very purpose of the act, to make the litigation end, or for the smooth functioning of the parties. This is why this is very important, a statute. So interpretation basically makes a bridge between the statute. It acts like a bridge between the making of the statute and interpretation of the statute. This is a process, continuous process. Try understanding. Once you read several times, you read only, then you get into mind, right? The same way, understand, interpret, draw many conclusions, only then you come to a correct conclusion to meet with the objective of the act. So see here, we have two friends here standing. For him, it is 3. For him, the one who is on the right side, for that person, it is 3 sticks. Whereas for the person who is standing here, it is 4 sticks. We have seen so many WhatsApp messages cropping up. It is always the attitude that changes. For the one standing on the other side of the parking, on the right side of the parking, it may be number 6. But for the one who is standing on the left side of the person parking side, it may be number 9. So it's all the perception, but understand the intention. Before we go with classifications of interpretation, we'll just see the questions if we get any. Mr. Raghavan, I didn't get your question correct. Will the instrument comes under contract? Yes, a contract can give rise to an instrument or a deed. If so, how can you file a suit since social agreement is void? Yeah, social agreements are void. So there is no question of, say, for example, you have an invitation inviting you for a party or a wedding event. It is a social invitation. And in case the wedding event did not happen, you can't sue them, right? So you can't take it as a documentary value. What is extinguished? I told you, right? Extinguished is losing one's right or the liability. Relinquishment, I have given you an example. In partition, if three brothers got a share of A, B, and C, and if brother B leaves his right and gives both his share B half and half to A and C, that is extinguishment of right. Your B is losing his own right in the property and sharing his property to A and C. That is extinguishment. That is relinquishment, means losing one's right. Parchment paper, it is the substance. Yes, a deed is an agreement. Ambiguity. Ambiguity is nothing but the confusion. A confusion that arises when it is not clear. When the situation is not clear, when the word is not clear, it is called as an ambiguous situation or as ambiguity. I hope I made everything clear. Yes. So till now we have seen what an interpretation is, why interpretation is important for us, what are the stages of interpretation. Like we have to first go through the preamble and then go through the interpretation clause. Then we have seen basic terminologies that are involved in the interpretation. Then we have seen how important interpretation is to bridge the gap between. Now let's go with another very important, interesting topic, that is classification of interpretation. How interpretation is classified. Interpretation is classified in two categories. One is legal and the other one is doctrinal. In legal, it is again subdivided into authentic and usual, whereas doctrinal, it is again subdivided into grammatical and logical. What is legal interpretation? A legal interpretation is nothing but when the rule of law is there and it binds the judge while interpreting the law is called as a legal. Means it goes as it is to the statute. A legal interpretation based on the statute, a law that is existent. Then in the legal interpretation, you have subdivisions. One is authentical and one is usual. Authentic means authorized, authoritative. Authentic means an official source gives you a law, and basing on that, a judge comes to an interpretation is called as a legal interpretation. Means legislature enacts the laws, and after legislature enacting the law, in case of any enforcement of a right or liability, you go to judiciary. This judiciary takes up the statute made by the legislature, then comes to a conclusion. This process is called as legal interpretation through an authentic source. Authentic interpretation, authentic legal interpretation. So it is formal, authoritative, authentic. Whereas usual, basing upon the custom. Because one of the important source of law is custom. How many of you know that? It is through customs only that we come across many laws. So, say for example, our Hindu Marriage Act or Muslim Marriage Act or Christianity Marriage Act, these are all formulated basing on the customs that they follow in their respective religions. Okay, so the legal interpretation, the judge takes the interpretation in the usual way how the custom or the previous case laws have been decided. That is legal interpretation. Then comes the doctrinal interpretation. When the judge has to discover the real or true meaning of the statute, then it comes to the doctrinal. Means the first one, legal interpretation. As per law, the judge takes the words as it is and they derive the conclusion. Whereas in the second case, doctrinal interpretation, they will discover the real true meaning of the statute, the intention of the statute. In that doctrinal interpretation, again, there is a subcategory of grammatical, where the court applies the ordinary rules of speech for finding out the meaning of the statute. Grammatical, as it is. Don't use your intention there. Don't bring out any brain there and just go into the brains of the other person. Are you all getting my point? In doctrinal interpretation, grammatical interpretation is nothing but you are taking the word as it is. Don't go beyond the words. Don't go for the literal interpretation. Then you have to understand the second category as logical interpretation, where the court understands the intention behind the statute. Here, the intention of the lawmaker is very, very important. Clear? So, the interpretation basically is divided into two categories, legal, doctrinal. In legal, it is authentic, basing on the statute. And the second category is usual, basing on the customs. In doctrinal, go for the grammatical interpretation either, where grammatical interpretation just go by the words, don't take the intention of the legislature. Then goes with the logical interpretation. Logical interpretation is nothing but taking the intention of the legislature. As I told you, interpretation is a step-by-step process. Here is the process. First, read. Then understand, interchangeable. Read the statute, understand it, interchangeably understand it, like keeping both the parties apart, just cross them, understand from that point of view and understand from this point of view. Understand the statute from A's point of view. Understand the statute from B's point of view. Then come to a conclusion, then come to an interpretation. After coming to an interpretation or the conclusion, it leads to construction. Here we come across a very new term called as construction. Till now we have the document, deed, instrument, but all these things are aiding us to understand the statute, that is interpretation. But now we are coming to the other word called as construction. What is a construction? After you understand something, you will come to a conclusion. That conclusion is nothing but the construction. So it is like all these bricks, cement, sand, all these things you put together. You are trying to make up something, a room, and after all these things are over, a building is constructed, just like that. A final output is the construction. And the inputs for understanding all these things are called as interpretations. I hope I'm making myself clear. Interpretation, construction. These two words are seeming to be very interchangeable, but there is a very slight difference between them. Important difference, obviously. That important difference is it is very difficult to say when an interpretation ends and when the construction begins. When it is beyond the direct expression of words, that is construction. So it is an interchangeable process. We don't know, we can't just say, okay, now interpretation is concluded, now construction is started. No, we can't say that. It is both a process of going hand by hand. Both interpretation and construction, they go hand by hand. But one thing I can make it clear, interpretation is an understanding of what is given in the statute, whereas construction is bringing out a possibility of what it can be done after understanding is called as the construction, which is nothing but in simple language, I can tell you it is a conclusion. After you understand something, you come to a conclusion, right? That is construction. We'll see the differences between interpretation of and conclusion with a break of just 10 minutes. We'll get back within 10 minutes. Yes. Right back with us after a power break. We'll see the difference between the interpretation and the construction. Interpretation. Interpretation, as we have been always discussing, it is the art of understanding the meaning of the word, the sense of the word, which means the literal meaning of the word and the intention of the lawmaker. So it is the art of ascertaining the meaning of the word and the true sense in which the author intended to make that happen. Whereas a construction is held to be the drawing of a conclusion. After you perform the stage of interpretation, you come to a conclusion, right? From the statutes beyond the words. So a conclusion is arrived in that situation where your words are clear enough, you need not go for the conclusion, because the word itself concludes that it is this, the meaning is this. But when the word is not clear, when the intention is not clear, you go beyond the lines, you go between the lines, and then come to a conclusion is the construction. Understood? So construction is an additional process added to the interpretation. That is the conclusion stage. In interpretation, the court adheres to the plain meaning of the language that is used in the statute. Whereas in construction, when the words are not plain, as I told you earlier, when you have ambiguous words, when the words are not plain, then the court has to determine whether the wording that is applying to that situation or not. Clear? So interpretation and construction, though they both go hand by hand, interchangeable, they are one after another processes, there is a very slight difference between both of them, which means interpretation is the process of understanding a situation or a word, whereas construction is drawing to a conclusion. Drawing to a conclusion. I have this very interesting example when I've been going through. This is very interesting and funny too. Let's go through this while understanding what an interpretation is, what a construction is. We have a social invitation like this. You are cordially invited for the marriage celebration of Bunty and Bubbly. And the celebration is on 1st April, and mind you, this is through an email. Okay, so the substance that they have used is email, electronic. On 1st April 2020, at the first floor or second floor, Ragging Hall, Teasing Street, Mocking Road, Mixif City, and the pin code is 420. Yes? Funny, right? Yes. Now let's go further. Read the terms and conditions for guests. Number of people present, maximum 2 people are allowed on one card. Mode of communication, mobile phones are strictly prohibited. Gifts, gold, silver, diamond, etc. may be only given as gifts. Dress code, completely white, completely blue, or completely red color. Dress may be worn. Dance form, Bhangra, Gidda, Lavani, Ghumar, and Garba may be performed. This is a social invitation. This is a social invitation or social document, you can say. And it is not creating any right or liability on any person, so it is not an instrument. It does not have any effect. Legal effect is not there on this because social agreements are void in nature. Till now, we are clear. But why are we discussing this example here at this point of time? We are discussing this to understand what an interpretation is. We are nowhere relating this to having a legal effect, but just to understand what interpretation is, we are understanding this, right? So the wordings go like this. You are cordially invited. This is a document basically, but it is not an instrument because it is a social instrument and it is on a substance and it is in the written form. It is recording a fact. All these things are there. So it is a document. But since it is not creating legal effect, it is not an instrument. As I told you, every instrument is a document, whereas every document need not be an instrument. This is a very perfect example for that statement. Now, whose marriage celebration is going on? Bunty and Bubbly. And I told you, in a statute, when you're reading it, is, was, may, be, shall, will, or, and these words, even though they are small in nature, short in nature, they play a very vital role in understanding a statute. When the wedding is taking place, it is taking place on April 1st, 2020 at the first floor or second floor. Here comes the role of interpretation. First floor or second floor. Till now, on 1st April 2020, Bunty and Bubbly marriage celebration is going on. Till now, it is clear. We need not go for further interpretation in that. Whereas the second line goes like this: at the first floor or second floor. Here arises an ambiguous situation. So one who is attending the wedding have to go to first floor or the second floor is the confusion here. This is called as an ambiguous situation. Ambiguity. In this ambiguity, when the ambiguity arises, comes the picture of the process of interpretation. Are you all getting my point? Where it is taking place? At the Ragging Hall, Teasing Street, Mocking Road, Mitsif City, and the pin code. So the address and all is clear. Only ambiguity that arises is first floor or second floor. We have to interpret that. That is the first stage. Then comes the terms and conditions. Number of people. It is very clearly written, maximum 2 people are allowed on one card, which means 2 or less than 2 are allowed, 1 or 2 people. Clear. In this, there is no ambiguity. Mode of communications. Mobile phones are strictly prohibited. Mobile phones are strictly prohibited in the sense, are they allowing pagers? Are they allowing walkie-talkies? Are the important questions to be decided. Now again, the situation for interpretation has arose. Here, the intention for them to prohibit the mobile phones is they wanted everyone who are present there to enjoy the wedding. So in that case, even a pager and the walkie-talkie is also not allowed. So they are also strictly prohibited. That can be one type of an interpretation that a lawmaker can, that the judge can interpret. Then the gifts, gold, silver, diamond, etc. may be given as gifts, etc. The word etc. means to include more. It is an inclusive definition. It is not an exhaustive definition. If it is only gold, silver, diamond, over, full stop, then it is an exclusive definition, which means only out of these 3 we have to give any gift. But when the word etc. is included, it is an inclusive definition. It is called as an inclusive definition. And in this inclusive definition, which can be the gifts? Can I give a car as a gift? Can I give a dining table as a gift? Electronic or a plastic item as a gift? Glass, plastic, all these things will not be considered to be the precious materials for them, as it is understood through the previous examples that they have given, that is the gifts that are accepted. Now, are you all understanding what is meant by an interpretation? So from this, we are coming to a conclusion. Through these examples of gold, silver, diamond, we are coming to a conclusion, that is the construction. We are making a construction in our mind that, okay, so we are prohibited from giving the electronic or plastic or glass item as gifts. So we have to just give the gift that is there in that category only, which can include a pearl, which can include a emerald, which can include a ruby or something like that. But other than that, other gifts are not allowed. Dress code, completely white, completely blue, or completely red. Maybe or. So it is the choice that is given to the person who is attending the wedding. That is also correct. Then dance form, Bhangra, Gidda, Lavani, Gumar or Garba may be performed. So Kuchipudi, Kathak, Western, Rap, these are not allowed. It is very clear. So interpretation means when the words are very clear, when the statute is giving us a plain meaning, don't go beyond the plain meaning. But once you have an ambiguous situation like in the first floor or the second floor, then go for the interpretation beyond the words. Then coming to this etc., coming to the third point, gifts, there go for the interpretation and come to a construction. I hope I made myself clear. This is why we have been saying from the first, why do we need interpretation? We need interpretation because we have to understand the real intention of why the law has come into existence. And as I told you, to err is human. We don't know why that lawmaker has made that particular section at that particular point of time. The need have made him do that. But due to the changing of the scenarios, we have to change the perception, we have to interpret them to meet the very objective of the act. Always when the judges interpret any act, the intention of the lawmaker, the intention of the statute is very, very important for them. You can't violate or invalidate the intention and go beyond it. So framing of the laws with such a degree of precision that there is no ambiguity is very much impossible. No one is precise in what is being made. So we can't be precise in our regular language, and hence interpretation or construction is coming into picture. We are taking the help of the external aids and trying to interpret what is the real intention of the lawmaker is, why the act has come into existence. So whenever an ambiguous situation arises in the legislation, a confusion arises in the legislation, the intention of the legislature is to take into account through applying the rules of interpretation. These rules they play a very vital role in our conclusions. Therefore, we need interpretation and conclusions here. When the ambiguity arises, the judge just cannot fold his hand and blame the draftman, okay, now I don't mind, or it is nowhere responsible, I am nowhere responsible for what the draftman have done, for what the legislature has made. No, ours is a federal government where the governments are, even though they are separated in nature, we have three organs, legislature, executive and judiciary. Even though we have three separate organs, but all the three separate organs of the government have to go hand in hand. Only then the smooth functioning of the government takes place. Only then the people are, litigant free. Otherwise, there will be so much of confusion, so much of disorderliness that arises in the chaos that arises in the minds of the people. So when we are doing this, what he needs to understand is the social condition, why he has gone to that law. The mischief that was passed to remedy, what issue has taken place at that point of time, and in order to resolve that issue, what type of social condition made him give this solution. Then finally, give life to the intention of the legislature while they are enforcing it. Then only we can understand how important it is to interpret or to come to a conclusion or construct something while enforcing a agreement or a deed or any litigation. Intention can be implied or expressed. Implied. What is meant by implied? Implied means self-explanatory. It is explained by itself. One second. Intention can be implied or expressed from the language. Implied means it is understood from the words that this is what the intention of the lawmaker is at that particular time of. Whereas expressed, it is clearly written in the page itself, in the act itself. So implied is basing on the legal principles. We have to come to a conclusion. Whereas expressed is based on the verbal construction. The grammatical words itself, the plain meaning itself gives us the expressed way. In implied, usually grammatical interpretation is favored, whereas in expressed, to the logical interpretation. Because implied, we add legal principles, right? We have two types of interpretations, legal and doctrinal. In doctrinal, we have again grammatical and logical interpretations, right? So when it is implied, we first go with grammatical interpretation. What is the mind of the interpreter? We just go only if the grammatical interpretation is not working. So first and foremost rule, remember friends, first go always with the grammatical interpretation. When the grammatical interpretation is not meeting the purpose, then go with logical interpretation. Only then go with the intention of the interpreter. When the words are clear, when there is no absurdity, when there is no ambiguity, go with the grammatical interpretation only. Understood? And if it is expressed as it is given, the verbal construction is just enough. We understand using the preamble, using the interpretation clause, we understand the words very easily. But when it is leading to the absurdity, then logical interpretation should be used. That is what I told you just now. When it is strict and unambiguous, only grammatical interpretation can be followed. So, only thumb rule that you have to follow in your interpretation. When the words are clear, when the intention is more clear, clarity, don't go beyond the words. Just take the grammatical interpretation when you are understanding the intention of the language used in the statute. That's all. What is the role of judiciary in interpretation? Judiciary only has a very important role because legislature enacts the laws over or amends the laws depending upon the recommendations made by the judiciary or the various committees. But it is the judiciary only who will have to decide why the lawmaker has done this and decide what is good and what is bad and decide various rights and liabilities on both the parties. For him to understand and enforce the statute, it is very important to interpret, construct a statute in case of an ambiguity. When the words are clear, I am telling you again and again, when the words are clear, when the plain meaning is fair enough, don't go for any further interpretation, go as it is. Follow the thumb rule. But when the words are ambiguous, when it is leading to an absurdity situation means not in conformity with the statute. When your interpretation is not in conformity with the objective, the very purpose of the statute, that is an absurd situation. In that case only, go beyond the words, read between the lines, then understand what is to be taken as a construction. Only then you come to a conclusion. Then follow And in order to do all these things, the process, it is a step-by-step process. First, you have to read it, first you have to understand it, then interpret it, and come to a conclusion, which is nothing but a construction. So for you to interpret the first three stages, the reading, understanding, then coming to an interpretation. So doing all these things, you have several rules that are formulated, and these rules have to be followed by the judiciary when they are analyzing. These rules are nothing but, there are two types of rules, primary rules and the secondary rules. Before we go into rules, we'll just take some questions if there are any. 1 second. Even now my video is lagging. Please let me know so that I'll. Okay. When the ambiguity is found in interpretation, a right way to consider the plain definitions of law. Yes, when there is an ambiguity situation that arises in a statute, so the first thing you have to do is grammatical interpretation. Grammatical interpretation, if it is not working and it is making the situation even more worse, an absurdity situation arises, then you go with logical interpretation. To err is human is nothing but, it is very common for any human to make mistakes. Error is nothing but an error. So once a mistake is made, it can be rectified through the judiciary. Lawmakers, they can't be so precise that they are 100% perfect to make all the rules perfectly. That is why judiciary is here to safeguard the lawmakers in interpreting it, to understand the intention of the lawmakers and not to deviate the very objective of the act. We have several rules for interpretation and construction. There are, and these rules basically help the judiciary to come, or the tribunal, a quasi-judiciary body, or even we, the professionals, to come into a reasonable conclusion or a valid conclusion. The first one is the rule of literal construction. The second being the rule of reasonable construction. Then the harmonious construction, beneficial construction, ejusdem generis, the rule of hedons or mischief rule, and the exceptional construction. These are the rules which we are going to see in now and the next session. And we have secondary rules as doctrine of nocitur es ausis and doctrine of contemporanea expositio. First, let's go with the primary rules. The primary rules are like this. The rule of literal construction. When do you apply this rule of literal construction? When the intention is in the word itself. If the word amounts to only one conclusion, one construction, the court cannot hypothetically go for another construction. Are you all getting my point? When there is only single construction, then single meaning, single conclusion, court need not go beyond it. Court need not hypothecate some constructions or need not identify what the other conclusion may be or can be. This idea is if the statute itself is unambiguous. Unambiguous means when there is no ambiguity, when there is no confusion and it is very clear cut, the court shouldn't interfere in understanding further. Just as it is, the court have to give the decision. When the course of action takes the words, they arrive at the meaning in the first try if possible. The principle applied here is absoluta sententia expositore non-indigent meaning, which means a clear words need no explanation. Literally, you go with the word. The situation that is creating here is unambiguous. There is no absurdity at all. The words are very clear for you and it is understood on the face of it that this is law and this should be law. Only that much. Then go for literal construction. No need to go beyond the words, between the lines, into the minds of the lawmaker. No need. This is a very simple law. If two meanings are arrived at a situation, one is a narrower in nature and the other one is a broader in nature, which one obviously the legislation takes into consideration? See, legislation or the judiciary or anyone, the executive wing, they does not encourage litigation. Always they wanted an end to the litigation. They always tries to accompany and accommodate so much into this so that the people are free in nature. Okay, litigant free in nature. So for smooth functioning, obviously when a conclusion is arrived, when one interpretation gives two conclusions, one is narrower in nature and the one is broader in nature, we will choose the latter part, that is broader conclusion is only the important one. When a matter is not provided in the legislation, then it cannot be said to have been interpreted. When it is not there in the legislation, it need not be taken, right? If it is not mentioned in the legislation, it need not be interpreted. As simple as that. When something is not said in the legislation, which means we can't expressly say that it is an implied meaning. It is not implied. That is what I mean to say. Under literal rule of construction, I am speaking about. Mind you guys, in the literal rule of construction, when the words are not expressly said in the legislation, don't go with it. You need not interpret it. Don't take the headache of going it. When the words of the statute are clear, unambiguous, the words has to be construed in a natural, ordinary way without adopting any hypothetical construction. Don't add so much of mixer on this to understand it. Just go as it is. We have a very simple example for us to understand this scenario. Sohail, a director of the company, who is not being personally concerned or interested, financially or otherwise, in the matter of a motion proposed before the board meeting. He did not disclose his interest, although he has the knowledge that his sister is interested in the proposal. So here is a given situation where a Sohail, a director of the company, is going to attend the board meeting, and there is an agenda that is to be proposed and passed in the meeting. And in that agenda, he did not disclose that he is personally or financially interested with the company. Basically, he is not. But he knows that his sister is personally interested with the proposal what the company is bringing forward in the board meeting. Okay. Now, So because he is not personally involved, he did not make any disclosures. He did not make any declarations that I am personally interested or I am financially interested. What he did is till here. So he is restrained from making any disclosure of his interest on the presumption that he is not required by law to disclose any interest, as he is not personally interested or concerned in the proposed proposal. So what he did is, okay, because he did not disclose any interest or did not disclose any financial interest, presuming that because he is not personally interested, he did not reveal it. He made the presumption relying upon the literal rule of construction. If he is following the literal rule of construction, what he did is correct. Explaining the scope of the interpretation under this rule in the given situation, describe whether the decision of Sohail is correct or not. Here, what is happening? The nature of the concern or the company, it should be revealed. What is section 102 of the Companies Act says, whenever there is a motion that is proposed to be moved in a board meeting, and if any director is personally interested in the financial or any other way they are interested, they have to disclose. This is what the Act says. Now, there are two senses here. One is a narrower sense and the other one is a wider, broader sense. Narrower sense says what? The interpretation, what Sohail has come to a conclusion. Because I am not personally interested with the company with this proposal, because I am not financially interested with the company with this correct proposal, so I did not disclose. This is the narrower sense. But the broader sense speaks what? Sohail here means not Sohail he himself, but Sohail he includes his family, his relation, like the wife, the brother, the sister of Sohail also comes into picture. So as I told you, the literal rule of construction, if it is drawing two conclusions, one is the narrower conclusion and the other one is the broader sense of conclusion, we have to interpret the broader sense. We have to interpret in its broader sense by referring to any concern or interest containing to any information or facts that enable the members to understand the meaning, scope, implications, or the items. So what is required is full and frank disclosure. The intention of section 102 Companies Act is what? Anyone having any interest, they have to disclose it with the company. There should not be any suppression, there should not be any reservation. So there is no partiality. Everyone is equal to the company. Okay. For the instance, where the son or a daughter or a father or a mother, brother, sister is concerned in any contract or a matter, the shareholder should fairly be informed of it and the material fact disclosed to them. Here, a restricted narrow interpretation obviously would defeat the very purpose of the disclosure. So what Sohail has gone to the application of rule of literal construction, it is a narrower interpretation. Here Sohail means not only Sohail, but Sohail includes his son, daughter, wife, father, mother, brother, sister. So Sohail here doesn't only mean Sohail, but includes his family also, and any one of his family members also having a purpose, having a material interest in a proposed motion in the company, have to disclose to the company. This is what is important. So the broader sense would do good. In the given question, the Sohail did not disclose the interest in the matter placed before the board meeting because it is the sister who is involved there, but not he himself. So he is not personally interested and concerned with the proposal. But he should have obviously considered a broader sense. As I told you, when it is coming to a broader sense, when one situation is leading to a narrower as well as the broader sense, but everything is clear. What is very much clear here? Section 102 of Companies Act says whoever is, the nature or the concern or the interest, financial or otherwise, of a director. They are just saying the director. And here the meaning of director have to be again taken in broader sense, but not in the narrower sense to understand the interpretation. So the very objective is to see that there is no suppression, see that there is no operation, see that there is no reservation. So the object is clear, and hence we need not go for further construction. So here he should have considered the broader meaning of the provision of the law, and therefore, even though he was personally not interested or concerned in the proposal, he should have disclosed his interest. Understood? Any questions till now? Rule of literal interpretation. Can the construction override interpretation? See, construction and interpretation, they go hand by hand. They are interchangeable. It cannot override. Like, there is no supremacy here. Overriding powers only come when it is supremacy in nature arises. But here, these two are interchangeable. One after one, another situations these are. How do we come to a narrower conclusion or a broader conclusion? How do we know that? Yes, we can always know, because here the intention is very clear. Mukta, the intention is very clear here. The intention is to safeguard the company from suppression or reservation or oppression of the directors. So, director here only does not mean he himself. Director here includes his family also. So always take the broader sense only. We have to safeguard the parties. That is what is more important. Then coming to the next one, mechanical construction. Basing on the grammar, we go with literal interpretation. When it is purposive construction, it is based on the purpose of the legislation and consider the situation prevailing at that time. This is what is happening. That is, purposive construction means understand the intention. Then you go with intention. But if it is based on just the grammar, go with literal interpretation. Generally, the laws are construed in their popular meaning. Means their regular words, what they are used. Whereas technical construction, they follow them in case of a particular business or a transaction. Say, for example, we have a very interesting example here. 1 second. Popular construction. I can give you a very good example here. The word vegetable. The word vegetable is generally considered in the case of the sales tax. So, now the question is whether coconut is a vegetable or not. Coconut is the vegetable or not, or whether it is exempted from sales tax or not is the question. The first thing that they have said is coconut is not a vegetable, because usually vegetables are those things which you directly consume and which are healthy in nature. Directly consume means you say, for example, a potato, lauki, or an onion. These are all vegetables, tomatoes. Directly you cook with them. But whereas a coconut, you will add flavor to the vegetable you use coconut. Directly with coconut, you don't cook it, right? Just to add flavor to whatever is the dish that you are making, a carrot. So you add flavor to it by adding coconut. And they have regarded coconut is not treated as an vegetable, and these are not exempted for sales tax. So the issue is some vegetables, if they are vegetables, they are exempted from sales tax. But because coconut is not an coconut is not a vegetable, is what they have concluded. They are confined to the sales tax. This is the popular construction, example of popular construction. Generally, whatever is the popular meaning that we use, you take that as the interpretation. So here in this sense, in the popular sense, coconut can be treated as a vegetable, but technical sense, it is not. Technical sense, going on the technical basis, what is the conclusion that they can draw? Technical sense, they can say that these are not vegetables because they are adding flavor only. Basing on this example, another case law arose. Another case law arose whether ginger, lemon, and green chilies or red chilies, are they vegetables or not? Once they are not vegetables, they are to be brought under sales tax. Once they are vegetables, they are exempted under sales tax. So here what happened with this case of the coconut, they have not gone with the popular construction, but they have gone with the technical construction, saying that coconut is that which it is not a vegetable because it is just an addition that you are giving to add flavor to the vegetable. That's all. That is why in technical sense, they said that coconut is not a vegetable and hence it is liable to be sales tax. Over. Now, basing on this definition or basing on this conclusion, there is another issue whether ginger, garlic, and lemon, all these three things, whether it has to be under sales tax or not. The same thing again. Oh, alone with ginger, you will not cook. Alone with lemon, you will not cook. Alone with chilies, you will not cook. So what they thought, okay, because coconut is exempted, we will, coconut is liable under sales tax. We will have to also bring all these three things also as under sales tax, not to be exempted because these are also used on the technical sense. But then Supreme Court has overridden the judgment that has given by the High Court, saying that this coconut, green chili, and the lemon are not commercially used, but they are used for the purpose of cooking only, whereas a coconut can be commercially used, and these are there. Without these, the regular vegetable will not be done. This thing without coconut, yes, you can cook, whereas without this you cannot, and hence treated this category of lemon, chilies, and ginger under the category of vegetables and exempted from the sales tax. So what I meant to say is interpretation and construction, it depends only upon the interpretation of that situation, the word and the intention. It doesn't depend just merely because it is coming under vegetable or it is not coming under vegetable. So we have to try to understand. That is why the role of judiciary plays a very vital role. That is why I tell you guys, it is taking so much of time for the judiciary to conclude a litigation. The pending litigation is there because of that only. Because every stage we have appeals. Every stage, everyone feel, if I and my friend goes to the court of law filing a case, I feel my case is strong, they feel their case is wrong. I feel my interpretation has been taken into consideration. My version of words have been taken into consideration by the judge. That is why the judgment is in my favor. Whereas the other one feel I am correct in my defense, whereas he has not given my point and he will go for an appeal. So construction becomes very, very difficult part, and it is obviously a major part for us to put an litigation into end. That is why the litigation is going on endlessly, and the pendency is also like this. We can't just blame the judiciary for the pendency. Next, we have the case law on the literal root. It is the state of Himachal Pradesh and the Pawan Kumar decided in the year 2005. When the word in the statute involves any absurdity, repugnancy, inconsistency, then the grammatical sense must be modified, extended, or abridged only to avoid such inconvenience, but no further. So, when one word in a statute is giving you a confusion, is not allowing you to meet the very objective of the interpretation. So try avoiding that word, try to modify that word, or try to extinguish or extend the meaning of that word. But whatever you do, you have to come to the very purpose of the legislature, the lawmaker. What is the purpose of the act? Why is it made? That should be importantly understood, and that inconvenience to be removed and go with the literal rule. We have another case law, very interesting case law, whether the sale of betel leaves was subject to sales tax. The same which I have gone with coconut, lemon, ginger, garlic. The Supreme Court held that betel leaves could not be given in dictionary, technical, or botanical meanings when the ordinary and the natural meaning is very clear and unambiguous. Being the word of everyday use, it must be understood in the popular sense by which people are conversant with, as also the meaning which the statute dealing with the matter attributed. Therefore, sale of betel leaves is liable to be sales taxed, which means that same formula you go with this. There, the ginger, chili, and lemon, by taking the dictionary, technical, and botanical meaning, they feel that it is a vegetable. But just like that, you cannot come to a conclusion. Even a coconut, by taking a botanical meaning, they felt that it is a vegetable. But in the true sense, what is it? The true sense and the natural meaning in the sense how they are using it, natural usage. I told you, some have to be interpreted. When there are types of interpretations, you have authentic and usual. It is usual. What is the custom that is going on? That have to be interpreted. So here what is happening? The natural meaning is very clear and it is understood that it should be used in our everyday need. Only then it can be treated as a vegetable is what the technical sense has made. So understanding in the popular sense, even the betel leaf, even though it is a kind of a vegetable leaf, you cannot, consumable green leaf, you cannot treat a betel leaf as a daily vegetable, and it should be taken in the popular sense that it is liable to the sales tax. Understood? Any doubts till now? I'll go with the questions. In the Sohel's case law, the basic intention of the act is to disclose the interest, to disclose the financial interest, to safeguard the company from going into the operation. So that is what the basic intention is. The narrower meaning and the broader meaning only have to be taken into consideration. Yes, I hope I made myself clear. In our next session, we would go with the other rules of interpretation. There are other rules of interpretations. These will be the other rules of interpretation. When the literal rule of interpretation does not work, we will go with the reasonable. If doesn't work, harmonious. So basing on this, the judiciary have to interpret, and we see how important it is. The role of judiciary really plays a very vital role because it has to balance both the parties as well as the legislation. The lawmaker is very important for the judiciary. At the same time, the parties are very important for the judiciary because it is for them only that the country is being run, right? So in case of ambiguity, in case of confusion, the judiciary has to balance it very properly and to see that no one is being infringed. Not even the lawmaker is being infringed, because everywhere people try to crop up coming with the litigation, but nowhere they try to end the litigation, but judiciary is trying to do it. So we should be very supportive to it and see that whenever we are interpreting to or whenever we are drafting to, always think futuristically and always see that we are putting an end to the litigation, not to create more confusion, not to create an absurdity situation, and always see the parties are in the comfortable position. As a professionals, we have to do that. That is why we are here. We are learning all these things. So always think, guys, I'm telling you, this is very important. Whenever and whatever you're studying, you have to study keeping 5W questions in your mind. 5W questions. What are you studying? Why are you studying? Where are you studying? When are you studying? And with whom you are relating to study it. What, why, when, where, and who. These 5 questions, when. These 5 questions will have one H as a husband. It is one husband and 5 wives. This H is how. How are you relating it? Why are you reading all these interpretations? Why are we attending this session? So what is the very purpose of we doing all these things? Not only this, whatever may be the subject matter you take it, guys, remember all these 5 W's and one H. This H and 5 W's will change your entire perception towards your study. And once you logically know why are you doing this, what are you doing it, it is very easy for you to practically implement it and understand very easily. Just don't by heart it. And this subject, this particular chapter, I'm telling you, interpretation, students will neglect it, but please don't neglect it, because the marks which are awarded will be freely sitting into your pocket. They come free of cost. Because how much you study, only this is there for the examiner to question you. Beyond this, there will not be any questions that can arise. You will be given with a situation, understand, analyze. The coverage is very small, but the marks awarded is big. You can just complete and keep it aside and be confident that, yes, I can score this much. That much easy your interpretation of statutes is. So in our next session, we'll continue with all the rest of the rules of constructions. Then we'll conclude with the chapter. Thank you, friends. Yes, sir.